What's it take for an officer to determine there's an emergency and then enter into your home?
Constitutional protections of your home are absolute.
It's a case that legal experts will be watching closely.
A new law just passed that fundamentally changes how police interact with firearms in your home, and the implications are so far-reaching that every gun owner in America needs to understand exactly what's happening before this framework spreads nationwide. This isn't speculation about future proposals or theoretical policy debates. This is active legislation creating a mandatory firearm seizure protocol that removes officer discretion entirely and establishes a retrieval process so complex that most people never successfully navigate it. Here's what makes this genuinely alarming. The law doesn't just allow officers to take firearms during domestic calls. It mandates seizure using specific legal language that eliminates all judgment calls. The statute uses the phrase shall seize, not may seize, which in legal terminology means there's zero flexibility. When police arrive at any household dispute, regardless of severity, they must identify all firearms present and remove them immediately. No warrant required, no hearing, no due process beforehand. What triggers this mandatory confiscation is disturbingly vague. If any person at the scene expresses fear, or if an officer determines that weapons could pose a risk, confiscation becomes legally required. There's no threshold for what constitutes fear. It's entirely subjective. A 2023 study from the Police Executive Research Forum found that officer judgment calls vary by up to 73% in identical scenarios depending on individual training and personal bias. That means your constitutional rights now depend on which specific officer shows up and how they personally interpret a vague emotional state. But here's what makes this particularly dangerous. Officers who fail to confiscate firearms face departmental discipline and potential legal liability if any subsequent incident occurs. This creates perverse incentives where police are pressured to seize first and sort out rights later. Departments are training officers to default to confiscation in any ambiguous situation to protect themselves from lawsuits, and the confiscation is just the beginning of a nightmare that most gun owners never escape. Getting firearms back after seizure isn't a simple administrative process. It's a deliberately designed obstacle course that most gun owners will never successfully complete. The law establishes a minimum 5-day hold period, but here's what they're not advertising. That's only the starting point. After 5 days, you must file a formal petition with the court, appear before a judge, and prove you're not a threat. Court filing fees alone average $400 to $600. If you want legal representation, which you absolutely need because one wrong statement can extend your seizure indefinitely, you're looking at $2,500 to $5,000 in attorney fees minimum. A 2024 analysis by the Firearms Policy Coalition found that 68% of people who had guns seized under similar temporary confiscation laws never got them back. Not because they were guilty of anything, but because they couldn't afford the legal battle or didn't understand complex filing requirements. The system gets worse. While your firearms are in police custody, you're responsible for any storage fees the department charges. Some jurisdictions charge $50 per firearm per month for secure storage. If you own multiple guns and it takes 3 months to get a hearing, you could be paying hundreds of dollars in fees just to store your own property that was taken without a warrant. Departments can also claim firearms were lost or damaged during storage, and you have almost no recourse for compensation. This law doesn't stop at traditional domestic violence situations. The language is deliberately broad enough to encompass almost any household interaction with police. The statute defines domestic incident to include disputes between roommates, adult children living with parents, elderly parents living with adult children, and even persons who have or have had an intimate relationship. That last phrase is completely undefined and left to officer interpretation. Mental health calls represent another massive expansion of confiscation authority. If anyone in a household is experiencing a mental health crisis and police respond, all firearms in that residence can be seized, even if they belong to someone else who's completely uninvolved. A University of Michigan study from 2024 tracked 1,200 mental health calls where firearms were present and found that in 82% of cases, guns were confiscated from family members who had no connection to the mental health episode and posed no demonstrable risk whatsoever. Welfare checks have become confiscation opportunities. If a concerned neighbor calls for a wellness check because they haven't seen you in a few days and officers decide to enter your home, they can seize firearms based solely on the presence of concerning conditions. What are concerning conditions? The law doesn't specify. A messy house, visible medication bottles, looking tired or disheveled, all potential triggers for confiscation. Officers are being trained to treat welfare checks as risk assessment opportunities, and internal training documents from multiple departments explicitly instruct officers to look for firearms during these calls. The demographics of who faces gun confiscation under these laws reveals a disturbing pattern that nobody in government wants to discuss openly. Analysis of confiscation records from states with similar mandatory seizure laws shows that rural gun owners face confiscation at rates 340% higher than urban residents, despite urban areas having significantly higher rates of domestic violence calls. The reason is straightforward. Rural homes typically contain more firearms, making them higher value targets for bulk confiscation, and rural residents have less access to immediate legal representation to fight back. Military veterans represent another disproportionately targeted group. Data from 2024 shows veterans are 5.7 times more likely to have firearms confiscated during domestic or mental health calls compared to non-veterans. The moment dispatch notes someone at the address is a veteran, response protocols change. Officers receive alerts about potential weapons training and combat experience, which triggers heightened confiscation procedures. PTSD-related calls, even minor ones, almost universally result in firearm seizure regardless of actual threat assessment. Elderly gun owners face a particularly insidious form of confiscation through Adult Protective Services involvement. When APS investigates seniors for potential self-neglect or vulnerability, their protocols now include firearm removal for safety. A 75-year-old widower whose house is cluttered or who forgets to pay a utility bill on time can trigger an APS investigation that results in permanent gun confiscation under the guise of protective services. The vulnerability being protected against is often nothing more than normal aging, mild forgetfulness, decreased housekeeping standards, or difficulty managing complex paperwork, but these become pretexts for permanent rights removal. Every firearm confiscation creates a permanent law enforcement record that follows you forever, even if you did nothing wrong and eventually got your guns back. These seizure records get entered into state and federal databases that are checked during every subsequent background check for firearm purchases, carry permit applications, and even certain employment screenings. A 2024 investigation revealed that 23 states automatically flag individuals in background check systems if they've ever had firearms seized, regardless of whether charges were filed or the seizure was later deemed unjustified. This creates a permanent digital scarlet letter that affects your rights for life. The career implications are devastating and rarely discussed publicly. Federal employment, law enforcement positions, security clearances, and many private sector jobs involving security or finance now automatically disqualify applicants who have any record of firearm seizure in their history. You don't need to be convicted of anything. The mere existence of a confiscation record is sufficient grounds for disqualification. FBI background investigation protocols obtained through FOIA requests show that any firearm seizure, even temporary ones, trigger mandatory character and judgment reviews that disqualify candidates for federal positions. Private employers conducting thorough background checks increasingly access the same databases, meaning a single confiscation incident can permanently close off entire career paths. What makes this framework particularly concerning is how it reverses traditional due process protections. In normal legal proceedings, the government must prove you pose a danger before restricting your rights. Under this mandatory seizure framework, you must prove you're not dangerous after your property has already been taken. The burden of proof shifts entirely to you, and the standard isn't even clearly defined. What evidence demonstrates you're not a threat? How do you prove a negative? The hearing process provides minimal guidance, leaving determinations largely to individual judge discretion. Some judges require only brief testimony. Others demand extensive documentation, including character references, mental health evaluations, and proof of secure storage arrangements. The inconsistency means your rights depend not just on facts, but on which judge happens to hear your case. There's also the timing problem. Court dockets in many jurisdictions are backlogged for months. Even if you file your petition immediately after the 5-day minimum hold period, getting an actual hearing can take 60 to 90 days or longer. During that entire time, your firearms remain in police custody, accumulating storage fees. You're unable to exercise Second Amendment rights, and the confiscation record is building in databases that will follow you permanently. If you miss any filing deadline, fail to appear at any scheduled hearing, or make any procedural error in your paperwork, the process resets, or your firearms can be declared abandoned and destroyed. The system is designed to be complex enough that most people without legal representation will fail to navigate it successfully. The enforcement incentives create additional problems that compound over time, because officers face potential liability for failing to seize firearms that later get used in incidents. Departments are training for maximum confiscation rather than minimum necessary intervention. Internal training materials obtained from multiple police departments show explicit instructions to err on the side of seizure in any ambiguous situation. One training module states, "If you're uncertain whether seizure is warranted, always seize. You can never be faulted for preventing a potential tragedy, but you will be held accountable for failing to act." This creates a one-way ratchet where the default answer is always confiscation, because that's the only option that protects officers from subsequent criticism or legal exposure. The statistical evidence bears this out. In jurisdictions that implemented mandatory seizure frameworks, confiscation rates increased by an average of 340% within the first year, while actual incidents of domestic violence or firearm-related harm showed no corresponding increase. The laws are removing guns from people who pose no actual threat, but the bureaucratic and legal barriers to retrieval mean those firearms effectively disappear into the system. Storage facilities fill up, creating pressure to auction or destroy confiscated weapons. Some jurisdictions have begun fast-tracking destruction of seized firearms after 12 months if no successful retrieval petition has been completed, effectively converting temporary seizure into permanent confiscation through procedural complexity. What's particularly troubling is how this framework interacts with other legal restrictions. If you're subject to any other court order, protective orders, restraining orders, probation conditions, your ability to retrieve firearms becomes even more complicated. Some jurisdictions require that you have 0 pending legal matters before firearms can be returned. A traffic ticket, a civil lawsuit, even a dispute with your homeowners association that involves any court filing can be cited as reason to extend the hold on your firearms. The system creates interlocking barriers where resolving one issue reveals another, and the complexity ensures most people eventually give up. There's also the chilling effect on reporting. If people know that calling police for any domestic dispute, mental health crisis, or wellness check will automatically result in firearm confiscation that may never be reversed, they'll stop calling for help in situations where intervention could actually prevent harm. This makes everyone less safe while simultaneously expanding government authority to seize property without due process. It's a policy framework that maximizes rights violations while providing minimal actual safety benefits, and it's spreading to more states while most Americans remain completely unaware it exists. The question isn't whether this framework will expand, it's whether enough people will understand what's happening in time to demand accountability before it becomes the default legal standard nationwide.